Good afternoon, all of you. I am Harjot Kaur, Assistant Professor, Khalsa College of Law, Amritsar. Today, I am going to speak on topic of conditions of valid marriage under Hindu Marriage Act 1955. The Hindu Marriage Act 1955 came into force on 18 May 1955. It has total 30 sections. This act is binding on all the persons who are Hindu, Sikh, Jain, Buddhist and who is not a Muslim, Christian, Parsi or Jews. Under Hindu law, marriage is considered as a union of two hearts or two families. In India, marriages are sacred institutions. There are 5 essential conditions for a valid marriage which are defined under Section 5 of Hindu Marriage Act 1955. These conditions are binding and definite, and violation of these provisions make the validity of marriage doubtful. There are 5 essential conditions. First condition is monogamy, second condition is mental capacity, third condition is age requirement, fourth condition is prohibited degree relationship, and fifth condition is Spindle relationship. First of all, we discuss about the monogamy. According to Section 5, Rule 1 of Hindu Marriage Act, provide the rule of monogamy and prohibit the rule of polygamy and polyamory. Before this enactment, a person can marry any number of marriages, even if he has a wife living. According to Section 5, Subclause 1, a person cannot marry more than one marriage. At the time of marriage, no person has a spouse living. That means a person either a single, widower or divorcee. The violation of this provision make a person punishable under Section 494, 495 of Indian Penal Code 1860 and also under Section 17 of Hindu Marriage Act. The Honorable Supreme Court in Sarla Mudgil versus Union of India held that a person cannot contract a second marriage until and unless his first marriage is dissolved by law. Next concept is mental capacity. The Section 5, Clause 2 of Hindu Marriage Act deal with the concept of mental capacity. This clause was inserted by Hindu Marriage Amendment Act 1976. There are 3 conditions for a valid marriage. These 3 conditions are as follows. At the time of marriage, neither party is not incapable of giving a valid consent due to his or her unsoundness of mind. At the time of marriage, neither party is not incapable of unsoundness of mind and procreation of children. At the time of marriage, neither party is not suffering from a recurrent attack of insanity. If these conditions are not fulfilled, then the marriage rendered voidable under Section 12 of Hindu Marriage Act 1955. Then third condition is age requirement. According to Section 5, Clause 3, there is age requirement for a valid marriage. Before this enactment, age requirement for a valid marriage is 18 years and 15 years respectively. After Marriage Amendment Act 1976, the age requirement for a valid marriage for boy and girl is respectively 18 and 21 years. According to recent amendment, the minimum age for a girl is raised from 18 to 21 years. The violation of these conditions does not render the marriage void but punishable under Section 18, Clause A of Hindu Marriage Act, in which a person shall be punished with imprisonment for 15 days and fine of rupees 10,000 or both. According to Section 10 of Child Marriage Act 2006, a person who perform a child marriage shall be punished with rigorous imprisonment for a term which may extend to 2 years and fine of rupees 1 lakh. Next condition is prohibited degree relationship. Section 5, Clause 4 of Hindu Marriage Act deal with prohibited degree relationship. Prohibited degree relationship means a relationship when two parties are related to each other by if one is the lineal ascendants of the other, if one is the husband and wife of lineal ascendant and descendants of the other. If two parties are related to each other as a brother sister, as a uncle nephew, as a aunt niece. Violation of this provision make the marriage void under section 11 of Hindu Marriage Act and also person punishable under section 18 subclause B of Hindu Marriage Act, in which a person is liable for punishment of 1 month and liable for fine of rupees 10,000 or both. Prohibited relationship include a relationship by blood, by adoption, by legitimate, illegitimate relationship. Next is Spindle Relationship. Spindle Relationship means a relationship through same body. Section 5, subclause 5 of Hindu Marriage Act deal with Spindle Relationship. Marriage under Spindle Relationship is also void under section 11 of Hindu Marriage Act 1955. Spindle relationship are traced upward not to downwards. Spindle relationship means a relation in which a person cannot contract a valid marriage. But if the customs of both parties allow them to do so, then they can contract a valid marriage under Spindle relationship. In India, in ancient Hindu law, in intercaste and interreligious marriages are not allowed, and same Gotra and same Prabha marriages are also not allowed. But in modern India, same Gotra, same Prabha, intercaste and interreligious marriages are allowed, and person is not punishable accordingly. So from above discussion, we can say that for a valid marriage under Hindu law, a person should be a monogamous, should fulfill the requirement of age and should be of sound mind and does not come under the degree of prohibited relationship and Spindle relationship. Thank you.